We have Alex and Tom Anderson, Tom England, Alice, Jennifer. Jerry Collins is joining us with that vista in the background. So Darren's going to be a little late. Is Catherine Jean on the call?
I don't believe so.
And Eben, is Eben going to appear today?
Judge Cobb, this is Judge Hennett from Greensboro on the call. I just have my name on.
Yeah, we see you there. Welcome. And we have our esteemed president from the Ivory Tower, Mr. Willoughby.
Not far from the swamps.
So you see any reason why we can't get
He
going
can't
now?
be Jerry Collins, though.
I don't see any reason. We are missing, I think at this point, 3 members. So one of the agenda items is to approve the minutes. I don't know if we should wait for one of those to do that. We could always wait to the end to do that. But I think we can get started on the rest of it. Just so everybody knows, this is a live stream on, I believe it's YouTube. Is that right, Peter?
Yes, that's right. It is streaming live on YouTube right now. And I'll also just point out just a couple housekeeping matters for those of you to need a refresher from when we did this in April. I'm going to have most everyone muted except for the chair and Alex at the beginning. If you would like to ask a question or make a comment, please hit the raise hand button in the participants tab and we can acknowledge you. Of Zoom, if you don't know where that is, if you hit participants at the bottom of your screen, there should be a list, and one of the buttons at the bottom, you'll see yes, no, go slower, go faster, raise hand. If you do that, to be acknowledged, that will make for a more efficient and better run meeting instead of having everybody unmuted the entire time. Now that really is hopefully the last time you hear from me.
All right, well, thank you, Peter. Madam Director, welcome. Do you have any words of wisdom from the virtual world? I think you're muted.
There we go. I'm unmuted. No, I don't have any words of wisdom. The State Bar, for the most part, continues to work remotely. I haven't been satisfied that we're seeing enough change in the numbers to feel like we want to reverse what we've done. So we're just staying the course, but we're able to get our work done. Unfortunately, we're not able to have in-person meetings. And those of you who are on the council know that we're going to do the council remotely, the July council meeting remotely. But I think all will go well, and the work of the State Bar is getting done. So I'm just here to observe.
And we have the distinction this morning, I think, of being the first virtual meeting that ties into the quarterly meeting, right?
You are. You're very distinguished.
All right. We're very proud of that. All right. So let me first welcome everybody to the meeting and get the conflict of interest statement out of the way. Everyone, of course, knows that it's the duty of the committee members to avoid conflicts of interest and appearances of conflicts of interest in performing the duties as a member of the Subcommittee on Compensation of Court-Appointed Counsel and the North Carolina State Bar. Any member of the subcommittee who is aware of any personal conflicts or appearances thereof with respect to the matters before this subcommittee should disclose those at the meeting and at this time. Is there anyone out there with a personal conflict that we need to deal with? All right. Tom, did you raise your hand? Okay, hearing none, then we will get underway. Whitney, welcome to the meeting. We're glad to have you. You probably don't know individually all of the members, so I think we might go through a short introduction for your behalf. My name is Alan Cobb. I'm from Wrightsville Beach, North Carolina. My background is in the court system. I was a Superior Court judge. I retired after 26 years and have been a state bar counselor for the last 4. So who would like to go next? Alex, you're at the top of the screen and we'll just go across.
Sounds good. My name's Alex Nicely. I'm a deputy counsel with the North Carolina State Bar. Before this, I was a prosecutor and a public defender and did some private defense as well as a little bit of civil work as well. And I'm just happy to help everyone out with this.
Whitney, my name's Jerry Collins. I live in Paradise, as you can see from the background, in Murphy, North Carolina, where the sky is just that blue and the clouds just that beautiful this morning. And I'm a small town, small time practitioner.
Tom?
Tom, you're muted. There you go.
I'm Tom Anderson from Pilot Mountain. It's almost as beautiful as where Jerry Collins lives. A small town practitioner. I primarily do consumer bankruptcy. I do some court appointed work for juveniles and parents in DSS court.
Jennifer, you're with us and did an excellent job before with the minutes, so I know you'll do another excellent job today. Thanks. We're glad to have you. Tom, you're muted.
Oh, still muted, Tom. I think we got you. There you go. You're good.
And did you not hear me before?
It's Tom. We're talking with Tom Englam.
Oh, okay. I was confused.
Tom, your microphone doesn't seem to be sending audio here. You've got you unmuted, but you might want to see if you've got something clicked on your computer here. Still not hearing you. We're still not hearing you, Tom. Why don't we come back to Tom?
All right, we'll come back to you, Tom. Mr. President, you're next.
I'm Colin Willoughby. I practice law in Raleigh with McGuire Woods, and I'm a recovering prosecutor.
And Alice, we've had the benefit of your comments, but Judge Hennett, let us hear from you, please.
Judge, you're muted. Judge, if you could hit the unmute, Judge Hennett.
Okay, hello.
Yeah, we got you.
Oh, okay. I'm here. Let's see. I'm sorry. I'm physically here. That I was formerly an assistant public defender and then a superior court judge. I stepped down from the bench in 2018 and in my second year as counselor to the bar.
So that looks to me like everybody that's on the screen has had a say except for Tom Angren. Tom, have you worked your mute button out yet?
Where's my pencil?
Still can't hear. Is anybody hearing Tom? I can't. Okay. What do you suggest there, Alex? Work with him while we go along?
Yeah, we could do that. Peter, do you think, call into the phone number line, or what would be the best way to do this, Peter?
I will chat with Tom on the side if you guys want to just continue.
Okay.
All right, well, the next order of business is the approval of the March 30th 2020 meeting minutes. Are we in a position to do that now, Alex?
I think we still have the same people. Technically, we have, let me see. 1, 2. Yeah, I think we actually do have a quorum, so, of actual members. So we can do that.
All right, so I trust everybody received a copy of the March 30 meetings minutes that were emailed to you. Does anybody want to put forward any corrections to those minutes? Seeing no hands or no one voicing any corrections, the minutes are approved. All right, and Darren's still not with us, is that correct? Hadn't heard from Darren?
I haven't heard from Darren, no.
Okay. Well, Whitney, again, thank you very much for joining us. Of course, Darren is very familiar with you and has highly recommended you and thought that you would be an excellent person to come and speak to us today. I think we all have our own impressions of the delivery of the service of indigent defense across the state. But we probably all have erroneous understandings of just where it's delivered and how it's delivered and all the resources associated with IDS. And so we're very excited to hear from you, and perhaps you could just give us the Indigent Defense Service Primer 101. And so we're all have a basic understanding of what's going on in the state of North Carolina. So we'll be better educated to perhaps come up with some way that we can assist that mission in trying to formulate some type of position paper or something like that to perhaps aid you in what y'all do in your mission. So I'm gonna turn it over to you without further ado. If you'd give us a basic introduction of yourself and your background, and then we'd love to hear from you. Thank you very much.
Well, first, thank you very much for having me. And second, I hope that Darren didn't sell you a false bill of goods. I am always happy to talk about the North Carolina public defense system, though. That is certainly true. So I'm very happy to be here this morning. I'm very happy to give you a primer. One reason why everyone may have slightly disparate understandings of the North Carolina public defense system is because it really is a patchwork across the state. So keeping that in mind, I will try to give you Indigent Defense Services 101. If I am covering things you know and don't need to learn more about, please just push me. Actually, let me back up and give my introduction, and then I'll give you a little bit of background on the presentation I'm going to give and ask that the host allow me to share my screen because I do have a PowerPoint. My name's Whitney Fairbanks. I am the Interim Executive Director at Indigent Defense Services. More comfortably and soon to return to my Deputy Director position, which I've been in for about 4 years now. However, I've worked with the North Carolina public defense system for most of my legal career. I started as an assistant public defender here in Durham County. And then when I've worked in other agencies with the School of Government at UNC, and then with the Administrative Office of the Courts, the public defense system has always been a primary assignment for me. So it really was kind of natural for me to join IDS in 2016 as the deputy director. The only reason why I have the sometimes tentative grasp on the North Carolina public defense system that I do is because I've spent 15 years working in it. It is not a simple system. It is a state administered but locally delivered system. which all of us are familiar with, and it presents various strengths and weaknesses associated with that design. I do want to say a particular hello to Mr. Collins and Murphy. Mr. Collins, I grew up in Bradley County, Tennessee, and was back and forth across that border most of my life. I miss it. It is paradise. And now, if possible, I don't know if I can just share my screen or if I have to have somebody do that for me.
I think I made you a co-host that should allow you to do it if you hit share screen.
Okay. Sometimes I feel like I'm getting really good at this technology, and then sometimes I feel really inept.
One of the, did you see, does it show up at the bottom, share screen, one of the choices?
It does. And
Okay.
I'm just having
Okay,
mouse
good.
problems.
Oh, no problem.
There we go. All right. I hope you're seeing a map of North Carolina. Are you seeing my PowerPoint presentation now?
Not yet. I'm not, at least I'm not seeing, I'm seeing a black screen at the moment.
Okay. Well, maybe this won't work, but
There we go. We see it now.
all right. Great. Thank you. All right. So I'm going to take just a few minutes of your morning, or as long as you'll let me have, and tell you a little bit about the public defender system in North Carolina and about Indigent Defense Services and the Indigent Defense Services Commission. I can split this up if you would like me to, but generally speaking, I plan to discuss the history of public defense in North Carolina, the organization of our system, the various ways we deliver public defense in North Carolina, and how that defense system is funded. If there are areas to you, please don't hesitate to just let me know. So I meant to tell you this at the very beginning of the presentation, and I apologize, but this presentation has been evolving for about 20 years, and virtually every slide is kind of constantly in flux. So what you're going to see is a presentation I've been working on very hard over the last few weeks to try to really flesh out as a primer for our incoming executive director, for folks at the NCAOC, and for folks at the legislature. So it really is a living document at this point, and I apologize if it looks, I apologize if that makes it distracting in some places. But what we have here is basically the timeline for the North Carolina public defense system. It's missing some very important parts that I hope to add to it, and then I'll share the PowerPoint with you as a document once I have it complete. But basically, we're celebrating 50 years this year of the public defense system as an organized institution in North Carolina. The Guilford County Public Defender Office opened its doors on January 1st, 1970. And the Cumberland County Public Defender Office joined shortly thereafter on July 1st, 1970. At the time, public defenders were appointed by the governor. A number of offices were opened between 1970 and say 2000, including the Durham Public Defender Office, the Forsyth Public Defender Offices, etc. And at the time, public defense was delivered much like it is today, in some areas by a state employed chief public defender and assistants, and in some places by private assigned counsel. And those are attorneys who run small firms or are members of larger firms who agree to sign up for what we call rosters and take appointed cases as assigned by the local court. This was managed by the Administrative Office of the Courts up to around 2000, up to 2000. In 1998, out of concerns about the quality and the cost associated with the North Carolina public defense system, the legislature commissioned a study commission. They issued their report in 2000, and in 2001, pursuant to that study commission report, Indigent Defense Services opened its doors and assumed control. During the course of this morning's presentation, I will use the word control, and I will use it in its loosest form, of the public defender system. Various things have happened since since Indigent Defense Services opened its doors. The public defender offices have expanded. The nature of compensation for private assigned counsel has changed. But one thing that was pretty consistent was that from around 2001, when we opened our doors, to around 2011, IDS exercised a certain amount of independence. And that independence is kind of fundamental to a healthy public defender system. We had financial independence from the Administrative Office of the Courts, but accountability to the General Assembly. And at various times, our ability to appoint or control the public defender offices enjoyed some independence from either the local judiciary or the General Assembly. However, as most people on this call will remember, in 2008, the Great Recession began. In 2011, the North Carolina General Assembly for the first time directed IDS to cut its budget, and to do that by cutting the rates we pay to private assigned counsel. And kind of beginning around that time, the General Assembly began to take a slightly more active role in the way Indigent Defense Services administered the public defender system in North Carolina. In 2012, they mandated a contract system, a large-scale request for proposal contract system. In 2013, they directed us to cut the budget for North Carolina Prisoner Legal Services, which is a nonprofit law firm with whom we contract to meet our constitutional obligation to provide inmates access to courts. And in 2015, the General Assembly gave control of our budget to the Administrative Office of the Courts. And in 2016, they mandated a new pilot. Kind of at the same time, public defender offices are being opened. Between 1970 and 2000, local communities approached the General Assembly for the creation of PD offices. Between 2000 and 2017, local jurisdictions and bars approached IDS. IDS would then recommend to the General Assembly whether or not to create a public defender office in a district. And then in 2017, we saw the General Assembly create a public defender office and expand an existing public defender office kind of independently of this local consultation that IDS historically has run. So I guess the point of this slide is that at various times IDS has enjoyed a certain amount of independence in controlling the way the public defender system has been administered. We've seen that kind of wane in the last several years, and we'll see what happens, if anything, in the 2020 short session or the next biennium. This is IDS's organizational chart in its very simplest form. What the study commission recommended and the General Assembly created in 2000 was a 13-member IDS commission at the top level of the North Carolina public defense system. That commission has direct control over IDS by appointing our executive director, and fairly direct control over our state level defender offices, which you will see listed in the bottom of the screen. They have direct control over these state level defender offices because either by rule or statute, the IDS Commission is the hiring authority for the appellate defender, capital defender, juvenile defender, etc. IDS provides administrative support to the public defenders who function with pretty great independence from IDS and the IDS Commission. And then we provide administration and support for the private assigned counsel, IDS contract counsel, and North Carolina prisoner legal services. And it's through this network that IDS meets the constitutional and statutory obligations in cases where low income, low wealth people are entitled to court appointed counsel. So our commission is, as I said, it's 13 volunteer members. They have to have significant experience in criminal or other cases subject to this article, such as parent defense or civil commitment or juvenile defense. They're appointed by a range of stakeholders, and that's really where their accountability comes in. The president, the Speaker of the House, the governor. Y'all have an appointee, and at this time, I believe that is not Darren. Darren's appointed by the Advocates for Justice, and so I'm struggling in the moment. Stacey Rubain, the State Bar appointed Stacey Rubain to the Indigent Defense Services Commission last year. Prosecutors and law enforcement officers are prohibited, and only 2 judges are allowed. We have a district court judge and a superior court judge, and members can serve up to 2 4-year terms. What they do, as recommended by the study commission, is to develop and improve public defender system programs. They appoint state defenders and the IDS director, and they're really the folks who are statutorily not only authorized, but required to work with the IDS director and the districts on determining the methods for delivering legal services for eligible persons. That is an authorization and a requirement or a responsibility that's provided for in 7A 498-5. But as I mentioned at the beginning of the presentation, the legislature has been increasingly willing to direct the commission to establish pilot or other programs where the legislature has determined the best way, at least to compensate, if not to provide public defense in a community. And then kind of chief among their responsibilities is to establish the policies and procedures for distribution of appropriate funds, including compensation rates for our attorneys. Along the way, they've worked to maintain and operate regional and district public defender offices. I should say here that while the statute long has mentioned regional defender offices, North Carolina does not currently have a regional defender office. That's not to be confused with the fact that we do have regional defenders. I'll talk a little bit more about that later. But at this time, we have not kind of created super districts over which there is a regional defender. Kind of constantly is under discussion because there are areas of the state that would perhaps benefit from an institutional presence like a public defender, but which will never have a demand that would make a public defender office cost effective unless the role was being shared with other districts. So Indigent Defense Services, that's the state agency. That's the office that I work for. We're located in Durham, North Carolina. And we provide fiscal oversight through billing policies, standardized hourly and expense rates, and auditing. And we work with folks at the local level to determine alternative service delivery and compensation methods where appropriate. Some of you may be familiar with this. Across the state, we have attorneys who provide representation in the defense role in treatment courts, either drug treatment courts, veterans courts, I guess I should call them therapeutic courts. And these folks may do it in what's called an attorney for the day or session capacity. In other areas, we have uniform fees, and in other areas, we have contracts. Again, when we're doing it the way we were designed to do it, we work with local officials, the bench and bar, to figure out the best methods of meeting the needs and the best way to compensate the attorneys. And as a result, we do have kind of a patchwork of delivery systems and a patchwork of compensation models across the state of North Carolina. We develop and provide training, manuals, performance guidelines, other resources for defense counsel. I don't know if any of you have had an opportunity to visit our website. It is a very information-heavy website. There are tons of resources for defense attorneys and tons of resources for defense attorneys who represent adults in criminal proceedings, children in juvenile proceedings, parents in child welfare proceedings, but it's a very resource-heavy website. And we work to provide those resources both for private assigned counsel and public defenders. We maintain statewide rosters for counsel and potentially capital and capital post-conviction cases. I think outside of the Superior Court bench and the capital defense bar, it may not be well understood that while in the vast majority of case types where a person is entitled to court-appointed counsel, a judicial official, a judge, a clerk, etc., will make the determination and the appointment of counsel in the capital arena. So for all potentially capital, proceeding capital, and capital post-conviction cases, it is the executive director or her designee who appoints counsel. And we've worked really hard over the last several years to, as I said, kind of create a robust resource-heavy website, to create listservs that are subject matter specific, and e-blasts and other ways to communicate with the legion of attorneys. There are over 2,000 attorneys across the state of North Carolina who have, at least at one point during the past fiscal year, provided representation in a court-appointed case. That's a lot of people to try to get information to. So what we've seen since Indigent Defense Services opened its door is some increase in cost, but that's modest when compared to the increase in dispositions. Our spending is growing at a much slower rate than the growth in the 5 years preceding the creation of Indigent Defense Services. And we've also worked both with the district attorneys and with other judicial officials on establishing cost controls and potentially capital cases, including what we call the exceptional case policy and pretrial budgeting policies. And then kind of flipping back to the resource support, we have created a number of resource support positions. These include the juvenile defender, the forensic resource counsel, regional defenders in contract counties. So we have 2 regional defenders who provide direct support to the attorneys who represent court-appointed folks in 17 counties, kind of in the central part of North Carolina. We have a public defender administrator who provides a lot of support and guidance, both through training and through HR resources to our chief public defenders across the state. We have a research department, and this is somebody I would avail you of if you have questions about public defense. By statute, we are required to create data and reports so that we can monitor the quality and the cost of public defense in North Carolina. And so our research director was one of the first people to join the team in the early 2000s. And she has spearheaded a number of really great research programs that have led to some really good innovation in public defense, not just in North Carolina, but across the United States. She's conducted studies of attorney average hours, capital case costs and outcomes. And then one of the most amazing things she's done is through some grant funded work, she created the Systems Evaluation Project. And that creates a qualitative analysis of public defense in North Carolina by creating a handful of key performance indicators that can be used to kind of monitor the health at the state and very local levels. And it's been instrumental in our ability to kind of fashion the appropriate delivery and compensation models in local districts. And has been instrumental in our ability to answer questions as they come to us from the General Assembly and kind of protect our modest slice of the pie, if you will. So I'll tell you a little bit about the public defense system. So the way we deliver public defense in North Carolina is, as I've said several times, a patchwork. Representation is provided by 17 local public defender programs covering 18 districts. And I know at the beginning I said we don't have any regional defenders, and that's true. But we have the appointed chief public defender for the first district, so that large rural district in the northeastern part of the state, also provides coverage for the second district, because we were having a very difficult time finding enough qualified attorneys in the second district to provide representation to eligible folks. But at the time, the General Assembly and the executive were not that keen on creating new public defender offices. It was kind of immediately post Great Recession. And so we simply expanded an existing chief's office into the second district. There's an error on this slide. There are more than 3 statewide public defender offices. There are 5. The appellate defender is a statutorily created office that predates Indigent Defense Services. The capital defender, the juvenile defender, parent defender, and special counsel. So for the folks on this call who've mentioned that they do some court-appointed work, these folks, the chiefs in these state roles, also serve as kind of resource counsel to you. Wendy Sotolongo, who is the parent defender, while her office principally handles appeals, she also works on a policy level with the state DHHS and the General Assembly, and she also provides consultation services to parent defenders at the trial level. Dolly Whiteside, who is the chief special counsel, also an office that long predates IDS. She does the same. She works on policy issues at the state level. She provides support to attorneys who represent folks in danger of being committed to a facility. And she works on contracts and other delivery system issues throughout North Carolina. So you may be kind of getting that we're a pretty streamlined organization. We don't have a deep bench. There's not a lot of redundancy, but everybody does kind of everything to keep the system running. And then finally, we have private assigned counsel, almost 2,000 of them across the state of North Carolina, who provide work in each of the case types for which IDS is responsible for providing representation. And they do so under a number of different compensation models. The model we're probably most familiar with is hourly, but there also is contract per session and flat fees. I've mentioned them already, and I'll come back to them shortly. So the state defender programs, I've kind of talked about this already. Most of them are localized in Durham. However, the juvenile defender is actually in Raleigh, and both the capital defender and special counsel have satellite offices. Special counsel in the areas of the state where there's a state hospital, and the capital defender in areas of the state that enable him to provide resource and training to attorneys at the local level, so that we can ensure that at least, or work to ensure that at least one attorney in a capital case is from either the county or the district where the case arose. So there are various strengths and challenges in the public defender offices. An immediate strength is these are institutional actors. They work on system issues and they work in the system. Historically, local districts have occasionally been resistant to the creation of a public defender office, but never has a district that had a public defender office created regretted it or asked that it be removed. Once there's a public defender, it usually becomes instrumental in the system fairly quickly, and the system generally from it and to like them once they get them. There's an efficiency that comes in enhances the public defender's caseloads and are able to specialize. And there are certain savings for courts and for counties, which are better able to control their jail populations and better able to move their caseloads forward. Other strengths include the supervision, training, and development of attorneys. They become kind of laboratories for experimentation and ways to improve outcomes. They're very predictable in their costs. If they're not necessarily a savings right now to the state because of the unsustainably low rate we pay private assigned counsel, they are predictable. We kind of know, despite fluctuations in demand, how much each office is going to cost us on a year-to-year basis. And they are also able to institutionalize other expert services that that can improve outcomes for their clients. So investigators, most offices have at least 1 to 2 investigators. A couple have paralegals, and I think 4, perhaps 5 right now, actually have social workers on staff. they can be very expensive to start up. And historically, some of you may have heard from folks who either do this work or because you do the work, that historically IDS has run out of funding at the end of many fiscal years. In recent years, we have not run out of funding, but where we have cut it close, it has been because we have either opened or expanded a public defender offices. There's a large initial outlay of costs for IDS and for the counties. It can be difficult to retain qualified, experienced attorneys. And certainly that's true in an environment where there's very little room for merit raises, and cost of living adjustments can be modest at best. I think that this is an issue that the public defender offices share with the district attorney offices. There is, since 2011, a decreased cost effectiveness especially in areas with low volumes of work. In at least one case, we've created a public defender office understanding that it never would be cost effective, but that it was the only way to meet the constitutional and statutory requirements of a public defense system. And since we were forced to cut the PAC rates, and as they remain unsustainably low, the public defender offices have not been as cost effective. Some of that is because of overhead costs associated with the chief PD's salary, support staff, and other resources. And then, of course, those of you who have worked in the judiciary as a state employee, you will understand that while IDS lacks the appointment authority for the chief public defender, this means that we have much of the responsibility for the public defender offices, but very little of the authority. They have immense independence from us. They answer to their local bench and bar. However, IDS often remains accountable for public defender decisions. And this is not dissimilar from the administrative office of the courts and the elected judges and the elected DAs and the elected clerks. So I should update some of these numbers, but I'm glad this FY 2015 is up here. So another way that we provide public defense across the state of North Carolina, and actually the way we provide the vast majority of public defense in North Carolina, is through local and statewide private assigned counsel rosters, PAC rosters. So in fiscal year 2015, we paid more than 2,500 PAC to handle approximately 167,000 cases. In fiscal year 2019, that number had shrunk to 2,000 PAC. So we are seeing attrition in our lists. And some of this is because of the hourly rates we are able to pay private assigned counsel. If you look at it this way, the General Assembly directed Indigent Defense Services to cut its private assigned counsel fees in 2011 in order to balance our budget. And so we've financed this balanced budget that we've achieved over the last 9 years on the back of private assigned counsel. Another way to look at it is these are folks who provide expert services to the state of North Carolina and have not received a single cost of living adjustment since 2011. We have been able to make some very small, very targeted increases to the rates attorneys are paid in high-level felonies, in low-level felonies, and in capital cases. But the vast majority of the work done in the North Carolina court system by the public defenders is in the district courts, where we pay $55 an hour. In 2018, we conducted an overhead study of private assigned counsel. At $55 an hour, most private assigned counsel cannot afford to hire one full-time staff member for their office and take any money home. And I'm happy to share that report with you. But the result is we are seeing an immense amount of fatigue in our PAC rosters. And we are seeing increased attrition as people leave public defense work or leave the practice of law, and those ranks are not being refilled. So what happens in the hourly rates? That's the traditional model. In that case, an attorney will sign up for a roster. When a person is determined to be eligible for court-appointed counsel and approved, then the attorney will be assigned to represent that person and would agree to do that for an hourly rate of $55 to $85, depending on the case type. When the case is disposed of, that attorney will fill out a fee application and submit it to the court for approval. The clerk will submit it to Indigent Defense Services, and we will pay the attorney the rate for the number of hours worked. That's been the system for as long as I can remember, and I believe was the system really before IDS came into existence. It has created a significant burden for our private assigned counsel during this public health emergency, because in the vast majority of cases for which we compensate people, the disposition is the trigger for payment. And because the courts have slowed down, if your case is a non-essential case, in other words, if it is not one of the case types that the Chief Justice has determined must proceed for basic due process requirements, then you're not going to dispose of the case. There will be no trigger and you won't get payment. We have worked really hard to let attorneys know throughout the state that we will pay interim fee applications during this time period, and we will do so happily in order to keep some money in their banks and keep the lights on. But it has presented a big burden for a number of attorneys. In fact, we were looking at a request from attorney for some financial assistance with training, and our chief financial officer was able to determine that between the beginning of March and the end of May in 2019, this attorney billed Indigent Defense Services $17,000. In the same time period in 2020, the attorney billed IDS $6,000. So many of the private assigned counsel across the state who are doing this work already under significant financial burdens really kind of walked off a financial cliff mid-March 2020. And we have been working very hard on finding creative ways to help them continue in this work, so that as the courts ramp back up, and someday perhaps post COVID-19, when we see a return to pre-pandemic charging policies and jailing policies and pre-pandemic court policies, that we will have attorneys who are able to stay with it during this time and can continue the work as the demand really increases again. We also use flat fees for cases in some counties. We have a so-called pilot from the General Assembly. It was termed a pilot in a special provision, but then we're supposed to report on it every other year. So I'm not sure it truly is a pilot, but these are in the district court where it has been, where we have determined based on statewide averages what a reasonable fee would be in the average case. And then we have the RFP contract systems. So one of the great strengths and challenges of the PAC system, some of the great strengths include this broad knowledge from a variety of practice areas. It's an extremely flexible workforce. which is crucial in areas with low volumes of work. They have a really great ability to accommodate changes in law or procedure. And they're good attorneys who generally don't want to work full-time as public defenders or don't want to work full-time, but really either because they love the work or they feel strongly about the work, want to continue to provide representation in court-appointed cases. I think it's probably easy to understand that one of the great challenges of the PAC system is that with at least 2,000 attorneys across the state, there's very little ability to provide supervision or development. There's little ability to provide resources and training that meet the demand, and particularly that meet the demand where it is. And there's less predictability of cost. So I mentioned the flat fee schedule. There are some strengths and weaknesses for that too. I won't spend a lot of time on this, but I will note that flat fee case fees have inherent disincentives. Those include a discouragement to attorneys from disposing of all pending charges against one client together, because that because they'll only be able to file for compensation in one of the cases, the lead case. They also can disincentivize spending a great deal of time on a particular case. But the real problem, I think, with flat fee cases, with RFP contract cases, of which you could say the same thing, that they disincentivize spending significant time on the case or discourage consolidation of cases, is that if we're not paying people enough, it doesn't matter how we're paying them. The flip side of that is if we are able to adequately compensate people, then it could be through flat fee, through contract, through hourly rate. A well-funded public defense system that uses flat fees is better any day than an underfunded public defense system that uses the Cadillac of delivery models. We also use a number of contracts to provide public defense in North Carolina. We have RFP contracts in 17 counties in the central part of the state. Those are requests for proposal contracts where attorneys seek and are approved for units or buckets of either misdemeanors, low-level felonies, or high-level felonies. And then across the state, we have about 150 what we call INCs, individually negotiated contracts. Those tend to be in specialized areas of the law, such as juvenile defense, child welfare, or civil commitment proceedings. These are the non-RFP contracts. We also have two large contracts, one with North Carolina Prisoner Legal Services. That is to meet our obligation to provide inmates access to court. And one is the Counsel for Children's Rights in Charlotte, which serves as the public defender of first resort for children who are facing proceedings in delinquency court or who are facing commitment. There are, as there are with the public defenders and with the flat fee compensation models, various strengths and weaknesses associated with the contracts. I mentioned a moment ago that they may disincentivize spending an adequate amount of time on an individual case. However, the contracts generally have more predictable costs than private assigned, than the hourly rosters or even the uniform fees. There are supposedly efficiencies gained from larger caseloads for the attorneys. And it gives us an ability to address system issues that we don't have in the counties where we are using hourly rates or uniform fees. One of the strengths of the contract system that has emerged in 2020 is that it has been a predictable and guaranteed source of income for our contract attorneys. So the contract attorneys are prepaid rather than postpaid. In other words, there doesn't have to be a disposition in a case for a contract attorney to be paid. He or she is paid at a point in the month and agrees to take all the cases to which he or she may be appointed going forward. Some of the challenges to the contract system: attracting and identifying the best attorneys for the contract types. It can make it difficult for young attorneys to gain experience because of the quality controls we had to establish in the system. There are very large areas and large number of attorneys that our regional defenders are required to oversee. And because of that kind of prepay unit system that we established, one that would guarantee quality or where we could do our best to guarantee quality and cost effectiveness, the contracts can sometimes be difficult to administer. In other words, when we prepay an attorney and he or she is not appointed to enough cases to meet that payment level, sometimes we spend an immense amount of time trying to figure out how to readjust our numbers so that the attorneys are paid adequately, but not overpaid, and vice versa. So it's a fairly complicated system on an administrative level, but it brings us good benefits in providing some institutional presence for indigent defense services in the communities that use the contracts. So finally, I'm going to give you an overview of IDS's finances. Where does the money come from? So IDS is primarily funded through direct appropriations from the General Assembly and through recoupment. Recoupment means that a defendant who is convicted is ordered to repay the value of services rendered, and that is collected either through probation or civil judgments or debt set-off. There are other smaller sources of income. We occasionally receive modest Cypre awards. We have, over the years and increasingly in recent times, sought grant funding, but principally it is the direct appropriation of the General Assembly or the recoupment. We have serious concerns about the effect that the pandemic will have on our recoupment in the coming years, particularly if we see this kind of nexus between increased poverty rates due to a contraction in the economy, leading to an increased demand on court-appointed counsel and a decreased ability to pay court fees, fines, and other legal obligations, including attorney's fees. All of this has meant that there's been a history of underfunding in the North Carolina public defense system, and indigent defense services has often ended fiscal years with shortfalls. There have been years when IDS has had to stop paying private assigned counsel as early as April. That means April, May, June, without any compensation to court-appointed counsel. What that also means is that in July, when we receive a new appropriation, the first thing we do with our new appropriation is take a big chunk of it and go back and pay off the debt from the prior fiscal year. So we are not only ending a fiscal year with a shortfall, we're starting a new fiscal year with a significantly lower appropriation with it, which to work with than it looks like on paper. We have not ended the last several fiscal years with shortfalls. As I said earlier in this presentation, that is principally because the private assigned counsel have received only the most modest of targeted increases to their hourly rate since 2011. In other words, we have balanced our budget on the back of private assigned counsel since 2011. In 2017 and 2018, we did make very modest increases to the hourly rates paid to attorneys who handle felonies in district and superior court and capital cases. We also opened, at the legislature's direction, a new public defender office in McDowell and Rutherford counties and expanded an office in District 3B, which meant that we did anticipate ending this fiscal year with a shortfall. However, our private assigned counsel payments took a nosedive in March, and we've had to cancel some training events that we normally would pay the School of Government for, which means we will actually end this fiscal year in the black, although I do not think that we will have much unspent money, so there will not be any serious reversion of funds. In other words, we're pretty much going to spend everything we were appropriated this year, but we're not going to overspend. So, as I said a moment ago, changes in the PAC rate have affected our annual demand and shortfalls. Historically, or not in the last several years, but historically in times of economic upheaval, we have seen the Office of State Budget Management demand or require reversions or restrict access to some of our receipts. We have seen the elimination, the transfer, and the reduction in budget for a number of programs we have administered. And in 2013, we saw a change to the sentencing for Class 3 misdemeanors, which was meant to, and ultimately did, reduce the cost to our private assigned counsel and public defender funds because it disenfranchised Class 3 folks charged with Class 3 misdemeanors who didn't have a requisite prior record. There was a significant amount of administrative upheaval associated with that, and we still occasionally get fee applications from attorneys who have been appointed to represent folks who are not entitled to court-appointed counsel. But that savings has really worked its way out of our budget over the last 6 years. And then, as I mentioned several times during the presentation, and particularly early on, changes at the legislative level with directives about how we actually deliver indigent defense services in North Carolina. So, given the opportunity, I do want to talk very briefly about some of the dangers of underfunding indigent defense. There's, on the national level, prior to the pandemic, a crisis in public defense nationally. It is an overloaded system. From state to state, you hear, I do not think it's too strong a word to say, horror stories of public defenders and private assigned counsel who are appointed to represent too many people and who are provided too few resources to actually do the work. North Carolina has stayed above that tipping point generally. We have always kind of danced right around that crisis point. There is no doubt that private assigned counsel are underpaid. There is no doubt that public defenders are overworked. On the other hand, we have a state administered system with direct accountability to the General Assembly. And so we have managed to kind of avoid falling off that cliff. That doesn't mean we haven't seen evidence in North Carolina of an underfunded public defense system. And right now I'm just showing you some images of various reports that have been released over the last 10 years and lawsuits that have been filed in districts where public defense really is at that crisis point. And as I said, while North Carolina has really kind of remained just at the tipping point, but not tipping over, that is not to say we have not seen the toll of an inadequately funded public defense system in North Carolina. There are exonerations of wrongfully convicted individuals, some of whom would not have been convicted had their attorneys at the trial level been appropriately resourced. And again, here are just a few of the headlines over the last several years of individuals who have spent decades in prison following wrongful convictions, and the cost to taxpayers for even attempting to make these individuals whole. And then finally, along the lines of the dangers of an inadequately funded public defense system, there are the collateral consequences. These have a tremendous impact on individuals who are court involved in North Carolina. And this is a screenshot of a tool on the UNC School of Government website. It breaks down the consequences in a number of different categories, but in a system that does not adequately fund the public defense, that leads to situations where individuals may choose to plead guilty in order to get out of jail, without a full understanding that while that is probably the right answer in the short term, but the wrong answer in the long term, then these collateral consequences can be huge barriers to reintegration into society. And we've seen a lot of interest across the spectrum, some real bipartisan support bipartisan support for criminal justice reform. The Koch brothers, who have worked with Eric Holder when he was with the Department of Justice, and at the North Carolina level, some really great left, right, center work to see criminal justice reform, such as the Second Chance Act. And so I think that now, over the last several years, and perhaps reinforced as we see the major fallout of the pandemic, and as we see civil unrest across the state and across the country, bringing everybody to the table for a discussion about systemic racism in our justice system. Now may be a time to invest in the public defense system, and where we'll see a lot of bipartisan support for that investment. At least that's my hope. I think that I really have addressed some of this during the earlier portion of my presentation, but some of the step backs we've seen in the public defense system, and particularly the kind of ossification of the unsustainably low PAC rates and the impact it's had not only on the folks who are entitled to court-appointed counsel, but on the folks who choose to dedicate either their entire practice or a portion of their practice to public defense, and the quality of life they enjoy continues to be an existential problem for the North Carolina public defense system. And various surveys of our APDs and our private assigned counsel over the last years have just really underscored that kind of existential level of those issues. All right, sorry if that seemed like a bit of an abrupt end, but I feel like y'all have been very patient and have listened to me dump a lot of information on you today. So if you have any questions, I would love to answer them. If I've taken all my time and you'd like to follow up with me later, I also am more than happy to do that.
Well, Whitney, that was excellent. And I think our priority is the end of your presentation as it relates to PACs, the private appointed counsel. And I'm just wondering aloud, is it possible for the for us to get a copy of that very excellent PowerPoint? We could study that, we could discuss that. That would set up for a wonderful question and answer session with you later if you donate some of your valuable time later down the road. Would you consider that?
I would happily do that. I need to make some updates to it and some changes, but I can send it to you probably within the next day or two. And then I am always happy to volunteer my time to talk about indigent defense and adequate funding for it. So you name the time, you name the place, and I'll be there virtually.
And please keep in mind, you know, our mission, I think, is how can we as a body help you with some type of influence. We can't get into funding, of course, but if we could get into an influence assistance position paper or recommendation to the Chief Justice, maybe something like that. Please be thinking about that as well. Now, your friend, Mr. Jordan, has entered our group. And Darren, I wanted to know if you had any comments. You heard a lot of that presentation, it sounds like to me. Can you add anything, your wisdom?
No, I would not even venture a chance to add what to Whitney. She is the expert on indigent defense in North Carolina. So good job, Whitney.
Thanks, Darren.
Good job. Alex, do you have any closing statements for Whitney or for the group? I think we've exceeded our hour. That's why we seem a little antsy right now, Whitney. But Alex, do you have any parting shots? Anything that you want to leave with the group?
Well, I did have one quick question and then I can get to that. Whitney, you did mention the 2015 statistics, and then I think you mentioned the 2019 statistics as well as a comparison, but they weren't on the slide.
Right.
You said, what were those for how many private appointed counsel and then how many cases?
Okay. That's one of the slides I have to update. Thanks for reminding me about that, Alex. But in 2015, there were about 2,500 private assigned counsel. In 2019, there were 2,000. The actual case numbers rose.
Okay.
And that's all in my annual report, which I also will share with y'all. But I'm going to update that particular slide. So we've seen demand either remain steady or increase, and we've seen our ability to meet that demand decrease when you think of it in terms of people power.
Okay,
Judge
great.
Cobb, can I ask, Whitney, I don't know whether you addressed this, but one of the things that we're looking at obviously is the sort of making sure that lawyers who do private assigned counsel or even public defenders and contract lawyers don't get in trouble with the bar for getting overextended or not taking care of their clients as they should. I've shared with them some anecdotal information, especially from Louisiana, but are you aware of any other places other than Louisiana where a public defense lawyer has gotten in trouble with their state bar?
Ohio and Missouri, and I can pull some.
That information might be good for us if you could send that to us also.
And
Because that's where I think
can
that's
talk-
where we kind of fit our ability to help you out is how is it affecting in the a lawyer's ethical duty to maintain with a client. So
Right. Well, and I can talk to Margaret too. I think we did a survey recently where one of the things we attempted to assess was kind of how many counties attorneys were signing up on lists. And that question was kind of a proxy for overextension, because obviously the greater your geographical spread, the harder it is to meet with your clients, the harder it is to be present in each court session where you might have a client on a calendar. And I will check with Margaret to see what that data showed.
thank you.
Very good.
And sorry,
Yeah.
just as a game plan, I think that it might make sense because we're pretty far over our time. But
Sorry.
if anyone has any pressing questions right now, then that's fine. The floor is open. But outside of that, what I was thinking is, if anyone has any questions, you could submit them to me, and then I can compile them and then send that to you, Whitney, if you wouldn't mind. And if you can answer them, great. If you can't, that's fine too. And if you wouldn't mind, also, if you could send the materials to me, the report and what you have there, and anything else that you think's appropriate, and then I can provide that to everybody else.
And you should feel free to share my email address with everyone who's on the call if you want to, but I'll send you the materials.
Patrice Hennett here. I do want to ask a question, and thank you very much for this excellent presentation. I'm a public defender at heart, but my question is this, as it relates to seeking attorneys in rural areas, what efforts are there in terms of organized efforts to get attorneys that will put some zeal in their representation and have the defense skill base, I guess is the best way to put it, for purposes of effective assistance of counsel?
It is a perennial struggle for us, Judge Hennett. We, at the beginning of the pandemic, the thing that kept me up at night was what I didn't know. Like, I do not know what I don't know what I don't know. I knew what was happening in Guilford County. I knew what was happening in Vance County. I have no idea what's happening in Ashe County or Surrey County, and our ability to kind of create this institutional presence has been limited. But we have where we have attorneys with whom we've established a close relationship and who reach out to us. We have dispatched regional defenders to assist them on a case-by-case basis. We would love y'all to know that we provide scholarships to training at the School of Government. We have worked with JurisLink and other vendors who do teleconferencing with the jails to create a system where we can compensate attorneys on the front end rather than on the back end. So where we know there's an issue, we really dig in and try to work on it. What scares me is that we don't know where the issues are.
Well, could you give it some thought and perhaps send feedback to us about ways that we can encourage some sort of recruitment? I know that judges cannot necessarily recruit lest that show some favoritism, but there are things that are seen by people that are in the courtroom on a regular basis in terms of number of attorneys that do capable and effective defense work.
I'm happy to do that, Judge Hennett. I will include that with my materials.
Jerry?
And in fact, we have a staff meeting today, so I will bring up some of these questions during staff meeting, and you will get the hive mind response on them.
And also, when you're addressing the staff meeting, if there could be some further education to judges about the way that the lawyers that work with prisoner legal services take on cases and the performance level, because in some instances, it may be months before we ever hear from them, and that sometimes gets to be a little sticky.
Okay.
Yeah, just some way to get some equal level of information and education about how that association works and how the court can depend on the attorneys that work for that service. That would be very, very helpful.
Jerry Collins.
Whitney, just very briefly, one of the questions that came to my mind during the entire presentation, and Judge Cobb mentioned it somewhat, but are you able to bring us more or less a list, or to give us your ideas, and perhaps not right now, but your ideas as to what the state bar could do concretely to assist y'all?
Yes, I
That-
can work on that.
That,
I'm happy to.
good. Thank you. I
Thank
think
you.
me, that would really help me to know where y'all see we can help. 2 or 3 folks from the IDS came to our issues committee meeting maybe a year and a half ago, and we spoke with them, and they basically presented to us maybe some of the needs, but once again, we didn't get a whole lot on really what the state bar could do to help, and I think that would help me. I don't know about the rest of the committee, but anyhow, that's all I got, Judge. Thank you.
Thank you. I think that's an excellent suggestion. And Whitney, anything you can do. I think we're compiling information. We're asking you what you think it would be best for us to do, and then we want to zero in and do what we can as pinpointed as we possibly can to help you.
Okay. Well, lucky for IDS and lucky for you, Darren is our chair, and he's a member of this committee and a bar counselor. So he and I and staff can work together to get something to you.
Very good. Thank you so much for today and your appearance, and we hope we didn't take up too much of your valuable time. Mr.
Oh, I
President,
think I took your time.
Mr. President, do you have any concerns or anything you'd like to say before we adjourn?
No, sir.
All right. Well, thank everybody for coming. Alex, this information will be forthcoming to you. You and Jennifer will compile that, I assume, and distribute, and we'll see what we need to do and when we need to reconvene.
Yes, sir. Just to reiterate, thank you for everything. This has been really helpful. If you have any documents or anything else, please email it to me, and I'll email you any questions that I receive or that I can think of in the meantime. And we hope to continue to work with you in the future.
Thanks to all. Have a good day. We stand adjourned.
Two.